Hi, this is Pam, your favorite paralegal and notary public from Brooks Notary and Litigation Support. Today I want to do a video about legal pleadings. And welcome back. Okay, so I'm just going to go on to a little in depth. This one in particular is going to be for the District Court of Clark County, Nevada, which here in Las Vegas is one of the main courts that, we do our legal thing in. So let's get to it. So as you can see, this is what the pleading looks like. This is called a caption, okay? And generally you would have the plaintiff's name and you would designate their title as plaintiff versus defendant's name and their title as defendant. Of course, if you have multiple plaintiffs, you put plaintiffs, multiple defendants, you put defendant. Depending on the type of matter, sometimes you would use petitioner, respondent. So it depends on the type of matter. You may see that in family law cases like divorce or things like that. So let's just start from the top. Here in Nevada, we require what's called a document code. So it designates which type of document is being filed with the court. So, it'll be a 4-letter code, 3-letter code that goes at the top. And then, of course, you would put, let's say, the attorney's name. Usually it's the attorney that's preparing these things. But, there are those DIY warriors out there and they will do their own thing. So then you would just plug in your information here. So name, address, phone number, email, which party you are, if you're the plaintiff or the defendant. And if you are representing yourself, you would put either pro per or pro se, depending on if you are the plaintiff or the defendant. So then, of course, you must always list the jurisdiction where the pleading is going to be heard or motion is going to be heard. So the district court, which is the court that we'll be, using for this example, and then the county. So Clark County is where Las Vegas is within Clark County and the state of Nevada. Most legal pleadings require this information. It changes up depending on the jurisdiction on how it will look, but generally this is what it'll be. So Nevada requires that you put in the case number, department number. If there's a hearing date, hearing time, you have to include all that in. And they also require you to place whether or not you want oral argument. If you want a hearing, you can put here oral argument is requested or oral argument is not requested. It's really up to the judge and the type of motion or document that you're filing, whether or not a hearing is required. But sometimes people just kind of want the judge to just read over the document. And yeah, I don't want to come, just read it and just tell me what it is. Tell me if you agree or not. So, and then there's the motion title. So if we say this is a um, motion for default judgment, per se. Default judgment is when the other party doesn't show up. You serve them the paperwork, you tell them the court date, everything, and the court date comes and goes, they don't show up. So you can ask for a default via a motion. So let's just say this is a motion for default. You have to put the title in the center of the document before you begin typing the body of your motion. And the first page is generally the introduction. So it starts off, it sounds kind of corny, but comes now, and then, of course, plaintiff or defendant's name. And then you will go in by and through his attorney if they are represented by a law firm. Of course, if you're not represented by a law firm, you would then put, um, comes now plaintiff or defendant, pro per or pro se, um, to respectfully submit this motion, yada yada yada, and so then just basically stating that you have to give your basis on how this motion is being brought. So it's being made based on the foregoing memorandum of points and authorities, affidavit, pleadings and papers on file if you already have a case open and you're just doing a motion. And then you would put the date, and then you would put down a signature block. You have to put a signature block every time when you're writing a motion. All right. So as I said, you would the next point would be number C, and then you would put what that reason would be. If it differed or if just added on to this, but it would be a different point with a different area of the law that supports that particular point that you're making. Okay. And so once you list out all of your points, then you will put in the conclusion. That's kind of like, when you're writing a paper and at the end you got to put your conclusion paragraph. So for the courts, this is pretty simple. I mean, some can be a little bit more elaborate depending on what it is that you're doing, what type of case it is, what you're asking for. So some of this can be a little elaborate. This is very basic, okay? So for your conclusion, of course, you number it, and then you would put it is for the aforementioned reasons that we respectfully request that this honorable court afford him or her the following relief. So this is saying, yeah, for the reasons that I listed above, I need you to please grant my motion. So here you would list it out to grant this motion, or in the alternative to grant, whatever demand you might have. So if you're asking for something in particular, then you'll say, okay, if you can't grant the entire motion, can you grant like the little pieces of the arguments that are brought up? And then you would kind of insert that here. And then if you have an attorney, then you would write in for attorney's fees, yada, yada, yada. So, it's pretty, I mean, it's kind of, for, I guess for someone who's used to doing it, it's pretty straightforward, but I hope this makes sense to you guys. That, this, it's not very difficult. And sometimes the courts are not very, strict when it comes to someone who is who's not generally part of the legal system. You know what I mean? So if you're pro per or pro se, not constituent, I'm sorry, if you're a pro per or pro se litigant, then generally, they understand that you don't know all of the proper formatting, all the procedures, all of that. So they kind of give you a little bit of leeway. So, but if you have those basic things, then you'll be okay. So I left this in here intentionally, as you see the little slashes here. These are basically like space holders because you're not supposed to have technically blank lines. So and you're not supposed to have a signature block on a page by itself. So, for instance, number 4 would be in any such other further relief as the court deems appropriate. So that's like saying, okay, you may not agree to grant the entire motion. You may not agree to to what I'm specifically demanding, but you might find something else that maybe I didn't list and you think, okay, I'll give you that instead of what you're asking for. So just for number 4, because I kind of skipped over number 4. But these little lines are here because number 4 will fit here, but a piece of the signature line may not. So then it'll look kind of funky because then you'll have the signature line missing a part of the signature block, the information from the signature block. So some of that might be, left out. And so that looks kind of tacky. So what you do is you would skip each line. I mean, you would do the 3 lines, the slashes, which here in Nevada I'm seeing is 3 lines. In California, we would do 2 lines. I've seen people do dots, different things, just kind of the little space holders. And you would then go to the next page at the top of the page, and then you would put your signature block. But you want to scoot down one of the numbers just so that it, shows that, okay, this goes to something. It's not just a random signature block. I know you're probably like, well, I mean, it has the title on there, so maybe, that will help. I mean, maybe it depends, but they can still be, protest it because um it's like you can add this to anything, you know what I'm saying? So if you have some wording from the previous portion of the document, then you're good to go. So then after that, generally when you're doing a motion, there's a declaration or like an affidavit that supports your motion. And so as you can see here, declaration of plaintiff defendant in support of whatever the motion is. And it's pretty basic. It's just saying that, you declare under penalty of perjury, that you are the plaintiff or defendant in the case, that you've read it and you understand it, and that the information that's in it is true, and that the exhibits are going to be filed separately. So here in Nevada, we don't just kind of smack the exhibits with the motion. We have to do a separate thing. So I'll do another video of that to show you how that's supposed to work. And then some motions require you to say that you don't have personal information like social security numbers and stuff like that, like sensitive personal information. And then, you declare the penalty of perjury, and then you put the date, yada, yada, yada. And then you sign it, and then you would submit that to whoever's going to be serving it for you, certificate of service. And you have the option of including the certificate of service on the back of the motion, or if you want it, you can create a separate certificate of service, and you would do that, you will file it separately. And so the way you would do that is you would create your caption, and you will remove this part because we don't have an oral argument for a certificate of service. But you remove that part, keep all of that info, and then you would change the motion title to certificate of service. And instead you would take out this part, and then you will replace it with, oops, went down too far. And then you will replace it with this information. And so this is basically you declare under penalty of perjury that you served this motion, whatever the title is, and then it'll say how you served it. In Nevada, most of the stuff here is e-file, which is great. Um, Unless you are initiating the case. So if you're like filing a lawsuit, then yeah, you gotta personally serve. So you gotta have a process server to serve it. And certain type of motions require that it be personally served, like an ex parte motion, for instance. Sometimes they require that it's personally served, because those are usually like emergency motions. Okay, but that's another video. So it's through e-file, and then you could put some law in there if you'd like. I mean, just preference thing. And then of course the date and who you served. So you have to include the name of the person that you served or the party that you served, and then you date it, then you sign it, and then you are good to go. And so your proof of service is done. Okay, and I'm realizing that I did not explain the numbers along the side of the pleading. So these are important because it comes in handy when you have to refer to something. So let's just say, for instance, if you're testifying on the witness stand, and the cross-examining attorney wants you to read your statement, they would be like, okay, well, can you turn to page such and such and such, which is the reason that we have page numbers. And then they'll be like, okay, we need you to read line 18 through 22. And so to go down to line 18 through 22. And that's all that they want you to read from 18 to 22, whatever that may be. So, so that's one of the reasons for the lines. It's also for, neatness. As you can see, everything's kind of lined up, you know. I'm a little anal about that with the lines and stuff being out of whack. I will sit here and tamper with it until it's right. And just so you know, with formatting, you would go here to the paragraph line, and most most people, what I see, they always do double space, and it drives me insane. What it's actually supposed to be, you go down to line spacing options, okay? And then you would click on line. You see down here where it says spacing. You see it says line spacing. It's supposed to be exactly 24. That is what it's supposed to be, okay? It's very neat and it lines up perfectly with the numbers, unless the numbers are not formatted properly. And just in case you weren't aware, this is how you do the numbers. So you know how you go up to the header and the footer, you just double click at the top or at the bottom. This is also considered the margin is also going to be affected by this header and footer, opening up the header and footer. Okay, I'm sorry, tongue tied a little bit. And so you can do the same thing here. you would just kind of highlight all of them, and then you would go to the home, and then you would go to paragraph, and then you would go to line spacing, and that should also be exactly 24 points. Okay, that is how you properly line up your wording and properly format your pleading. Okay, again, this drives me insane when the words are not lined up with the numbers, and there are specific areas in um the law, I'm sorry, the rules of procedure, that tell you where the spacing is supposed to start, like what is supposed to line up where. Like it even tells you where plaintiff and defendant is supposed to be. Like it tells you all of that. Like it's very, very formal in the way that it's supposed to look. But again, if you're a DIY warrior and you're doing it yourself, and the court knows that, they're not going to be too picky on it. They're not going to reject it because it's not lined up. Like there are attorneys who don't like line everything up. You know what I mean? So they're not very picky about it. A lot of them aren't. It's usually if you go to federal court, that's where it really matters. They are very, very meticulous. But that's another video. Okay, well, I thank you guys so much for watching. I appreciate your support. Please like, share, and subscribe to Brooks Notary on YouTube. You can check me out on Instagram, Twitter, Facebook, and now TikTok. So I appreciate you guys watching. Please leave any feedback in the comments. If you guys want to see something else, let me know. And thank you so, so much for your support.